All right, we got that transition? Great. All right, good evening, everyone. My name is Dwayne Urban. I am the creator and one of the admins of Maryland Gun Owners on Facebook, as well as the owner of Urban Defense LLC, Firearms Training and Consulting, and I will be the host and the moderator for tonight's event. Along with me again tonight is attorney Andrew Sauer from Sauer, Lord, Ernstberger, and Inslee. Andrew, why don't you tell everyone a little bit about yourself and your firm?
Good evening, everyone. I'm a partner, obviously, at Sauer, Lord, Ernstberger, and Inslee. I routinely appear all over the state in the district and circuit courts. Was up here back in 2021, had a wonderful shooting case. The Cecil Wake said all kinds of great things about me. We won the case, though, so I was happy about that. Guns, drugs, shootings, rapes, robberies, murders, wherever in the state of Maryland, if needed, I am there. I'm a lifetime member of the NRA. I'm an executive member of Maryland Shall Issue, and I routinely deal with firearms and whatever comes with them all the time in the courts.
All right, thank you, Andrew. Tonight, we're also joined by Chris Pruitt and representatives from the USCCA. Chris, why don't you step up to the mic, introduce yourself, and tell us about the USCCA, what it has to offer, and why it's important.
Yeah, so I know a lot of you guys have already seen me in some facet because you guys have been through tax reps classes, stuff of that nature. But for those of you who are not familiar with who I am, I work for Delta Defense, which is a service provider of the USCCA. Really what the purpose of the organization itself actually is to make sure that before, during, and after lawful acts of self-defense that you have some form of plan, right? It's very easy to press a trigger in the moment. It's very difficult to make the correct decision. And also, part of the reason why we're here is because what happens in the aftermath, right? When we start looking at self-defense in general, most of us don't plan for what the financial repercussions are of those pieces. So really what the purpose of it is basically a Netflix style training is the best way that I can explain it. You log in the same way you would log into Netflix. You go through and train at whatever timing is your convenience, right? So that may be 5-10 minutes a day. That may be 4 hours a day. It depends on what time you have. Now, once you get through all that sort of stuff, if you're forced to defend yourself in any facet, right, does not have to necessarily limit you to just a firearm. You want to make sure that you have some form of plan that can be able to afford the attorneys to defend you inside of court and also have something for the legal aftermath of if you are sued civilly and they win, you want to make sure that you have funds available to be able to pay those things on your behalf as well as things like bail. The USCCA is really all encompassing when it comes to all of those pieces, and I'm not going to bore you with the ins and outs of the insurance element of it, but we will be here throughout the course of the night. When you guys are on intermission, if you guys are not already members, please stop by the table, come by, and we can help you guys become members. If you are already members, most people do enjoy upgrading to have access to a little bit more training. We can explain a little bit more in detail why it is important to continue that training. So we're right next to the Tactical Shepherd table. Come back to us in the backhand corner during intermission. We can help you guys through that process, absolutely. But before I get going, because I know there's going to be a lot of hands up here, how many people are already USCCA members out of the group? Jeez. It's always a good bit. So I'm going to turn it back over to Dwayne, and we're going to get the evening kicked off.
All right, thank you, Chris. I also want to extend a great thanks to our event sponsor and co-host, Tactical Shepherd, offering high-quality firearms training right here in Cecil County. If you haven't had the chance to stop by and see them already, stop by their table in the back during the intermission or after the event and see what they have to offer, see what they can assist you with as it applies to your training needs and special offers that they may have tonight for attendees only. Additionally, Urban Defense and Sauer, Lord, Ernstberger, and Inslee will be in the back. We have a table back there. Check us out, see what we can offer to you. For those of you from the Baltimore metro area, Urban Defense is happy to assist you with your firearms training, including but not limited to HQL, wear and carry, force-on-force reality-based training program using the same equipment and techniques that we use in the police department. And last and certainly not least, we're very proud to announce the release of our new emergency trauma care training program. This course is designed for a civilian audience and covers patient assessment using MARCH and treating traumatic wounds, including but not limited to gunshot wounds, stab wounds, and other traumatic injuries. Taught by our expert instructor, retired paramedic and former TAC medic, Jerry Hines, in the back. So on the break, go and see him. That class is going to be in Baltimore County, November the 4th. Only 10 students will be permitted in that class, so we expect that to fill up very rapidly. Finally, if this type of content is important to you, subscribe to our YouTube channel. The information's on the table in the back where you can see content like this and similar topics on a regular basis. Hit that notification bell to be notified every time we drop new content so you can get more information in the back. You can scan a QR code and all of that. So on to tonight's event. Tonight, we will begin with a discussion on Maryland Senate Bill 1, which took effect on October the 1st. Essentially a Cliff's Notes version of it, or, well, what it was. Then we will present the recent court injunction, which I'm sure is why most of you are here, and what facets of the law that injunction impacts, which it does not, and how does it affect you. In addition, why it's important that you're here and that everyone is educated on what, in fact, these changes are. As we work through all of this, we do plan to take a 15 or 20-minute intermission. It'll be closer to 20 minutes in the middle of discussion, and we will let you know when that is. After those discussion points, there'll be a question and answer period, which I will announce. In order to make sure we can get all the information out, we ask that you hold your questions until the question and answer period. I promise you, you will have time to get your question heard and answered. Following the end of the formal portion of this event, you'll have the opportunity to meet with us, Andrew, myself, the vendors in the back, and ask any additional questions that you want to ask offline. Some housekeeping. Restrooms are on my right, your left, on this door back there that is conspicuously marked. They are a little bit small, but they are there. Also, in order to keep the venue clean, we kindly ask that you please pick up any trash and deposit it into the trash cans that are provided to help us return this location back to better than we found it. So I thank you for your consideration with that. And with that said, a special thanks to the venue, VFW Post 6027. It's my understanding that their kitchen and bar area is open, so please help support them. And also, I was asked to bring this up, and what a great time to do that. They are hosting a shrimp, beer, and beer event. They've covered all three food groups with this one on November, beef, and well, beef, yeah, of course. But on November the 4th, right here from 6 p.m. to 10 p.m., there's more information in the back. They have these flyers in the back. And the proceeds are to support the Veterans Outreach Program right here in Cecil County. So check that out. So as we begin tonight's event, let me start our discussion with a disclaimer and then a statement. So first, the disclaimer. All statements made during this event are intended for educational purposes only and are not intended to convey legal advice or create an attorney-client relationship. The host and the speakers highly recommend that attendees seek the assistance of legal counsel regarding any questions you may have regarding firearms laws in the state of Maryland. Now the statement. No one up here tonight serves as part of the Maryland General Assembly, and none of us, Andrew, myself, James, or anybody else, had anything to do with the laws that were passed or the injunction. So please keep that in mind when you're asking questions, making statements, or interacting with our guests and staff. So don't shoot the messenger, please. With that said, let's go ahead and get into it. Andrew, why don't you give us a brief rundown on Senate Bill 1 as it was passed, its intended effect and implications, and then we can kind of discuss the injunction and what its implications actually are.
Thank you, Dwayne. I'm sure everyone here is familiar with New York State Rifle and Pistol Association versus Bruin. That was the recent Supreme Court case from 2022 that basically said that states such as Maryland, where you had to have some sort of higher standard of good cause to be able to carry a firearm outside of your home, was unconstitutional. That caused, Maryland was no exception, tens of thousands of people to go and apply for their carry permits. They took the classes, they paid the fees, they did the training, they passed the qualification, they applied to the state police, and they got their permits. This caused terror to certain members of the General Assembly. Once again, I'm not in the General Assembly. I do not work for Anthony Brown, the Attorney General. No one asked me, was this a good idea? I'm only here to talk to you about it. So they sat down and said, quite openly and honestly, we need to contain the ability of the people to carry firearms. We need to curtail the Second Amendment as best we can. They did a lot of things that I care about, but I don't really care about tonight. They increased the permit application fees to $125. They increased the renewal fees to $75. Things where if you're now on probation for a DWI, you can't have a gun during probation, things like that. But the real target this year, the first Senate bill of the session, Senate Bill 1, also known as the Gun Safety Act of 2023, was passed. And it does a lot of things. It breaks down to 3 specific areas where you are no longer allowed to carry a firearm, as well as it's going to be now known as we push forward, the private building carry rule. They said you can't carry firearms in areas for children and vulnerable individuals. You say, well, I wonder what that is, but okay. Government or public infrastructure areas, that makes, once again, that's going to be broader than you would think. And then the ominous special purpose areas. What is a special purpose area? I'll tell you in a couple minutes. Violations of this, 1 year in jail or $1,000 fine or both. So areas for children and vulnerable individuals, let's start with them. They've added preschools, pre-kindergarten facilities, or the grounds of the facility. This is much broader than I'm sure a lot of you would think. When I was young, I went to this place called Learn and Play. My parents would take me there every day. I'm sure some of you know someone or have encountered someone that has a licensed daycare facility at their house. That would be covered under this. Once again, pre-kindergarten facilities, preschools, and most importantly, the grounds of the facility. So the lovely man or woman down the street that has a license to allow 6 children to come there during the day, that would now be a covered entity where you could not carry a firearm, period, on the grounds. So if you were going there to pick up your child, drop off your child, just going to say hi to your neighbor, you could not carry there. Private, primary, or secondary schools or grounds of the school. Under Maryland law, up until this, you could theoretically, it would not be a good idea, and there would also be issues with federal law. But under Maryland law, if you went to Boys Latin, Gilman, any of the other private schools, you could have possibly been able to carry a firearm there. Not a good idea, but maybe could have. Now, any private, primary, or secondary school, and once again, the grounds of the school. So if you are going to a soccer game there, if you are going to walk your dog there, if you are dropping a child off, if you're picking a child up, these would be all instances where this is covered under here. You could not carry a firearm. They added healthcare facilities, which runs the gamut. Hospitals, related institutions, ambulatory surgical facilities, a facility that is organized primarily to help in the rehabilitation of disabled individuals, a home health agency, a hospice, a facility that provides radiological or other diagnostic imagery services, a medical laboratory, an alcohol abuse and drug treatment abuse program. All of these places, no firearms there, period, moving forward. The next class we're going to talk about, government or public infrastructure areas. A building or any part of a building owned, leased, or used by a unit of state or local government. So remember how broad that can be. That can obviously be the Cecil County Executive Office building. That can also be the Cecil County Agricultural Co-op Outreach building. That can be the MVA. That can be anything else state or local government related. A building of a public or private institution of higher education. So that is going to be all colleges here, all universities here, private or public. This is also going to be things you would not think of. North American trade schools. This is very broadly defined. The community colleges, anything designed to cater to a post-secondary education, any kind of vocational program, any kind of computer educational building, anything like that, no firearms. Doesn't have to be owned by the government as long as it is designed as an institution of higher education. So be careful. A location currently being used as a polling place. So if you're going to go vote, which I hope everyone in here votes, if you're going to your polling place, you cannot carry a firearm there. If you are not even going there intending to vote, where I vote, it's a senior citizen center where people actually live. They could not go anywhere near the polling areas in their own building with the firearm. Bear that in mind. They've added a multitude of places that I'm unaware of any incidents occurring there, but I'm glad they're now covered. An electric plant or an electric storage facility, a gas plant, a nuclear power plant. So any of you thinking of going to the nuclear power plants in southern Maryland, do not bring your guns with you. Now, under these areas, and I have not actually seen a single sign yet, I'm sure they're out there, but at the main entrance, and this is, I can't wait till I have to argue this case. We're going to argue what's the main entrance and what's the secondary entrance. The law requires that only at the main entrance they display a clear and conspicuous sign saying that this building is owned or leased by the state or local government, and it's not permissible to wear, carry, or transport a firearm in the building or that part of the building. Once again, be very careful how this is written. Everyone can go through that door right there. Everyone came in here. If they determined that this was, it's obviously not, but was a government public infrastructure area, despite that being what everyone perceives to be the main entrance, if there's no sign there, but where we think the main entrance is on the other side of the building and we have the sign there, it's your problem, not the local government's problem. The biggest change here also is finally in the third area, the special purpose areas where firearms pre-injunction were not allowed, period. A location licensed to sell or dispense alcohol or cannabis for on-site consumption. There was no requirement that on-site consumption has to actually be occurring. On my drive up here, I passed several liquor stores. Depending on their liquor licenses, they may be licensed for on-premises consumption. Just because they don't allow it, that's not what the law says. They just have to be licensed for it. So you could not carry a firearm in any of those places. You could not carry a firearm at a stadium, and that is, once again, broadly defined. That's not just Camden Yards and M&T Bank Stadium and Cal Ripken Stadium. That's going to be pretty much any other thing you can think of as a stadium. A museum. I know, everyone knows what the Smithsonian is, but the local Cecil County Historical Society, that may also be a museum. Bear that in mind. A racetrack. I don't know what they meant, if they meant horses or if they meant cars. And from further research, I think they're okay with us not understanding which and just saying, how about neither? So once again, if you want to go watch the ponies, you cannot bring your firearm. If you're going to want to go watch the cars, you can't bring your firearm. Finally, video lottery facilities. And that's a facility in which players play video lottery terminals and table games and a casino. That's obviously going to clearly include casinos. But be very careful. If you are at a small corner store that does live keno is one of the things defined here, that could very well be a place you could no longer carry a firearm. Now, there are exceptions to these. If you're an armored car driver, things like that. So I'm sure there might be someone in here who says, wait, I'm an armored car driver. And the vast majority of you, those exceptions do not apply to. If you're the owner of the property, there may be exceptions. If you're the actual lessee of the property, there might be exceptions. But as a general default rule, you're not armored car drivers. You're not licensed armored car drivers. So you cannot carry in these situations. Next, and very controversially, and we're going to call it the private building rule, dwellings of another. So that means a house that's not yours. You can't enter or trespass there unless the owner or the owner's agent has given you express permission, either to the person or to the public generally, to wear, carry, or transport a firearm inside the dwelling. So if I want to go over to Dwayne's house and he has not told me, Andrew, feel free to carry a firearm there, I cannot carry a firearm there. If Dwayne had a sign up, something like this, that would qualify as permission to carry a firearm in there. But if I just show up to any one of you lovely people's house and there is no signage and you haven't told me specifically I can carry a firearm in there, it is now a violation of Maryland law to do so. We'll talk about it a little later with the injunction. Dwelling, though, that only means the actual part of the house that, or a building that provides living or sleeping facilities. So it wouldn't count as the yard, your shed, things like that, unless you sleep in your shed. So you could be walking your dog with your firearm and walk onto your neighbor's grass to talk to him. That would not be a violation of this. If he did not know you have a firearm and give you specific permission to enter, if you went in and had an iced tea, that would be a violation of this. It doesn't include the common elements of condominiums, apartments, things of that nature. It doesn't include the adjacent land. So you could, go, if you are in your apartment building, wear your firearm to go get your mail at the communal mailbox and vice versa. Another issue, non-dwellings. This is going to be everywhere else. Absent any other legal proceedings, as enacted, you could not wear and carry on the property of another unless the owner or the owner's agent has posted a clear and conspicuous sign indicating it is permissible to wear or carry. Once again, doesn't have to be this sign, doesn't define what a sign would be, but you'd have to have a sign like this. Or the owner or the owner's agent has given the person express permission to wear and carry on the property. So once again, this would be everywhere else in the state of Maryland that you do not own or directly lease, that is a building, whatever it is, any definition you want to come up with, you could not wear and carry in that building unless you had the owner's permission or there was a sign. And then the other big changes they made this past year, Maryland, it was originally a carry permit. While not tactically advisable, you were free to open carry. You could carry it on your head for all they cared. That has now changed. Now, if you are carrying and it is visible, or does everyone know what printing is? If you've got it concealed but not concealed well, that would be printing. If it is visible or if you are printing, that is now a violation. Your firearm has to be concealed. Now, a momentary and inadvertent exposure or momentary and inadvertent printing, that's okay, specifically under the statute. But once again, I look forward to representing all of you good people who end up testing this on a windy day and your shirt blows up and someone sees the presence of your firearm and is so offended they call the police and they come and arrest you. Please call me after that happens. So it's going to be a new day and age. If your firearm is in a vehicle, it now has to be locked in a container. Locked being the key and operative word. If you are not in that vehicle. Your firearm, your vehicle locking in and of itself does not count. It needs to be locked in an enclosed container. And once again, just to be clear, there are a million exceptions for police, correctional officers, armored car carriers, railroad police, security guards, things of that nature. But to the average, everyday one of you, there are no real good exceptions to this. Dwayne.
So, lots of stuff there. So, from the last discussion that we had, let's go through a few places just for everybody's sake. So, stuff like CVS's and Walgreens,
Once again,
under the old law, under the pre-injunction.
as enacted, that's how we'll say it. As enacted, no go. Unless they've got a sign, Walgreens, CVS, Rite Aid, couldn't carry a firearm there.
So how about this? How about, and again, pre-injunction or as written, a restaurant, Olive Garden, I don't know, anywhere that's so you can go and get a glass of wine and with your pasta, right?
Obviously, yeah, you could not carry in there. And once again, it doesn't say if you're drinking. It doesn't say if you're with a party that's drinking. It doesn't say if they're actively serving. So if you went to TGI Fridays with your family, you could not carry there. You could be sober as can be. If you rented TGI Fridays for a private party that did not serve any alcohol, could not carry in there. If a meeting of Alcoholics Anonymous had a meeting at TGI Fridays and they were all as sober as can be, doesn't matter, could not carry in there.
How about the private mom and pop restaurant that has one of these signs in the wall, but also sells alcohol? That's what we call a trap.
That's a trap.
That's a trap.
That's a trap. If they could put all the signs up they wanted, if they had a license to sell alcohol on premise, you could still not carry in there.
Which includes some liquor stores, even if they
Yes.
don't serve on premises.
Yes.
Depends on what their license says. All right, banks. How about banks?
You would think, oh my God almighty, we want to make sure people are going to the banks, they're transacting lots of currency. But once again, unless you're an armored car driver, unless there's a sign, you could not carry inside of a bank.
Okay, so homes, and I know you talk to this, homes of family and friends. You go to a family member's house for a birthday party. You pick up your kid from a neighbor's house for a birthday party.
You better hope they like the Second Amendment and they gave you express permission to carry on their property. There's no exception for family, no exception for friends. If you have, your parents, your in-laws, if they don't like the Second Amendment and they don't want to give you express permission to carry there, you cannot carry there.
The law is written and is very, very tricky.
As enacted, yes.
So, all right, here's one that is interesting. Walmart.
If you look on their website, it said they allowed concealed carry inside of Walmart. Do so at your peril, or check the website every time before you go. Because if they had removed that in the interim, in between the last time you checked and the day you chose to go, and someone wants to make a point of it, that's your problem, not Walmart's problem.
So we talked about daycares. We talked about small daycares inside of people's homes, doctor's offices, and patient first. Now, does that fall under the private property? Does that fall under the medical?
That would fall under the medical facilities. So once again, patient first, your doctor's office, your dentist's office. Doesn't matter if they want you to carry or not, you cannot carry there.
All right. Churches, places of worship.
Those are conspicuously absent from this legislation. So if, as enacted, there was a sign or if you had specific permission to carry there, you could carry away.
Okay. So the law as enacted, where can you carry or where could you carry? Well, was just driving down the road.
The state senator that sponsored this legislation, he gave numerous interviews when he introduced it, and he was very open and honest about this. He only wanted you to carry in your own home. Basically, if you could drive around in your car and carry in your own home. He did not want you carrying anywhere else. He was often asked, has there been a single incident where a lawful possession of a firearm by a permit holder was used for any kind of malfeasance? And there was not a single example that existed in the state of Maryland. Just the thought of the possibility that someone would do something. We have all these people that have been through training, been fingerprinted, background checks by the state police. They're clearly menaces up to no good, and we want to curtail their rights to carry. So he was very open and honest that this was by design to make it almost untenable for you to carry a firearm anywhere other than your own house or your own business in the state of Maryland, depending on what your own business was.
So it was by design, essentially, as we all know.
Absolutely.
And this was Senator Walt Stryker and former Senator Lee?
Yes.
Okay.
Yes. Senator Lee has now advanced up state government. She is no longer in the state Senate. She is now in the executive branch.
Both from Montgomery? PG?
He was from Montgomery.
Yeah.
I don't know where she was representing.
Okay. So, all right, so that is Senate Bill 1 as enacted.
Yes.
So now let's kind of talk about, let's not kind of do it, let's do it. Let's talk about the court injunction, where it came from, and kind of how we got to this point.
So, two groups of plaintiffs filed lawsuits against the state of Maryland, Governor Moore, various states' attorneys, Anthony Brown. Now, when this bill was passed by the legislature, Anthony Brown, his office gave an opinion, and they said that Senate bill, it is our view, is that Senate Bill 1 is legally sufficient and is not clearly unconstitutional. That's what he said. Some people disagreed with them. There were two groups, Susanna Kipke, and she owns Miss Kipke's Secure Gun Storage, and the Maryland State Rifle and Pistol Association were one group. And then a second group, Catherine, and I apologize if I'm mispronouncing it, Novotny, Maryland Shall Issue, the Second Amendment Foundation, and the Firearms Policy Coalition, they're the second team, filed these lawsuits against the state of Maryland in the United States District Court. So it's in federal court. And it got assigned to Judge Russell. And both sides, there is some minor disagreements between the two sides, between the plaintiffs as to where to fight, what to challenge. Are we challenging under the Second Amendment, the 14th Amendment, things that probably are very boring to you all. But they both challenged it, and they asked for an injunction. Now, an injunction is not the end-all, be-all. Just bear that in mind. An injunction being granted, that means that the court has reviewed the initial submissions by the parties and has determined that there are some serious issues that need to be reviewed. Now, they broadly challenged a whole bunch of Maryland firearm laws and regulations. So this is going to be a little bit broader than just Senate Bill 1. But for an injunction, the court considers four things: the likelihood of success on the merits, a likelihood of suffering irreparable harm in the absence of preliminary relief, the balance of the equities tip in the party's favor, and that the injunction is in the public interest. So, number one, are you likely to win if this goes all the way to trial? You can have the best arguments in the world, but if it's not likely to you win, too bad. Number two, the likelihood of suffering an irreparable harm in the absence of preliminary relief. So if Judge Russell had not granted an injunction, you could not carry a firearm until this was resolved. These kinds of cases usually take months, if not years. So there would be suffering. There would be, I'm sure, unfortunately, someone would witness a crime, be a victim of a crime, and not have a firearm with them for their own self-defense or the defense of a life of another. The third one, it's a legal standard. The balance of equities tip in the party's favor. And that's a fancy way of saying that when we consider what would be equitable or what would be fair, what would be the fair thing to do, it goes one way or the other. And then once again, that the injunction is in the public interest. So Judge Russell heard all of the arguments of all sides, and they challenged a lot of the parts of this law. We won't get too much into it from the outset of the various rulings of the judge, but they really, really came hard at pretty much the whole thing. They challenged the healthcare facilities. They challenged the schools. They challenged the private property rule, as we discussed. They challenged the casinos. They challenged the museums. Pretty much everywhere that one could challenge. And right Up until October 1st, I thought this was going to be go into effect. And then the Friday, right before October 1st, Judge Russell issues this wonderful, read it when you want to fall asleep, but it's still wonderful, 40-page opinion detailing his thoughts on whether or not this law is, as Anthony Brown said, legally sufficient and not clearly unconstitutional.
And they made it severable as well.
Yes, yes. The law itself, just another boring lawyer thing. The law itself, in the very end, contains a clause that says if a court throws out any section of the law, don't throw out the whole law. We want the rest of the law to stay in effect. And you only put that in a law if you are worried whether or not it's constitutional. So under Bruin, Judge Russell is looking at in 1791, when the Second Amendment was enacted, and in 1868, when the 14th Amendment was enacted, are there relevant, similar to historical regulations, analogies that can be drawn by the state to support regulating where you can carry firearms? And Judge Russell, and we're going to do this in a couple minutes, went through each and every challenge that was brought forth, and similar to baseball umpire, called balls and strikes, threw parts of it out and kept parts of it in. Now, an injunction, once again, is only the first step. There has not been extensive live witness testimony. There hasn't been cross-examination. There have been motions for summary judgment ruled on. So this is going to be quite a process, and this will continue to evolve. After Judge Russell renders an opinion, I'm sure the loser or the winners are going to appeal it to the Fourth Circuit. That's down in Richmond. They're going to take years before they render an opinion in all likelihood. And then whoever loses there may ask for an en banc. That's a fancy way of saying ask all the judges of the Fourth Circuit to review the opinion. And whoever wins or loses from there is going to appeal it to the Supreme Court, I'm almost certain. This is a 5-year process, probably. So while it may appear clear to some of us, while it may appear hazy to other ones of us, this is not going to be resolved today or tomorrow. And Judge Russell's injunction is good today, but you need to be very cognizant it may not be good tomorrow. And when it is like a light switch, when it is flipped, that is that. So be very careful. What you could do on Friday, you may no longer be able to do on a Monday. So just bear that in mind. And if you want to be lawfully carrying a firearm, stay cognizant of developments with the court.
So the injunction essentially puts those matters that were enjoined on pause
Yes.
until such time as they're unpaused or they're gotten rid of altogether.
Yes. And anything that is not unpaused pursuant to the law remains in full effect.
All right, so now would be a good time to take that intermission.
Sure.
So we're going to take 20 minutes, intermission, use the restroom, grab something to drink, and at 7:30 we'll be back here and we'll actually talk about what was enjoined and what its effects actually are. So thank you. Okay, all right, we're going to go ahead and get back started. So, everybody take their seats. Okay, so, you got a lot of papers there.
I do. 40 pages of wonder in front of me.
Fantastic. All right, so what do those 40 pages of wonder tell us?
So, looking for Maryland's historic regulation of firearms, we need to look to 1715, where Maryland had a colonial law that imposed criminal penalties against anyone of evil fame or a vagrant or dissolute liver that shall shoot, kill, or hunt, or be seen to carry a gun upon any person's land, whereon there shall be a seated plantation without the owner's leave, having been once before warned. That's what we got to work with, everyone, so please, careful attention. Do we need to read that again, or we get the gist? So, these plaintiffs, and let's talk about some other areas we don't cover yet. In Maryland, this is outside of Senate Bill 1. You cannot carry firearms in state parks, state forests, Chesapeake forest lands, property owned by the Maryland Mass Transit Administration, welcome centers, rest areas, scenic overlooks, roadside picnic areas, public school property, property of state buildings, Camden Yards complex, casinos, and a demonstration in a public place or in a vehicle that is within 1,000 feet of a demonstration in a public place after being informed by a law enforcement officer that a demonstration is occurring and being ordered to leave the area until the individual disposes of the firearm. These were all things that predated Senate Bill 1. So the plaintiffs challenged all of this, both under the Second Amendment and under the 14th Amendment. And the court sat down and went through them one by one. The court says, and this may be news to a lot of people, not to people in this room necessarily, but the plain text of the Second Amendment protects the individual's right to carry a gun for self-defense outside of their home. And as we view everything through that optic, let's go through them one at a time. Stadiums, racetracks, amusement parks, and casinos. The court said, despite arguments to the contrary, there are historic laws that would support that, so you cannot carry a firearm at a stadium, racetrack, amusement park, or casino. They said government buildings. They said there's ample historic regulation of laws forbidding you carrying firearms in government buildings. Loser there. School grounds. They said, the Supreme Court said it is well-settled law that they can prevent you from carrying firearms on schools or school grounds. So that is a loser. I was a little bit shocked by this. Museums. The court said there is well-settled law that you cannot carry a firearm in a museum. Mass transit facilities, well-settled law, cannot carry a firearm there. We did have several wonderful victories, though, with Judge Russell in the injunction.
So all is not lost.
All is not lost. He did have some major rulings that would be helpful. Number one, locations selling alcohol or cannabis. The defendants claim that, banning the carrying of firearms in bars has historic support. They were able to find a law from 1890 in Oklahoma that said you could not carry a firearm in a bar. They said that's not good enough. So it's 1890, it's Oklahoma, and because Oklahoma, not to get too complicated, but Oklahoma has traditionally been a Native American tribal land that is not analogous to what we have here in Maryland. So despite all the arguments, we don't want drunk people shooting each other, despite the fact that it would be illegal to do that already. Locations carrying, selling alcohol, you can carry a firearm there. Public demonstrations. They said, there's ample evidence of this. There's cases where, of course, we're all aware of, where there has been violence at public demonstrations. The court said that historically, there have actually been laws on the books that required you to bring a firearm to a public demonstration, not banning them. So, as of this second, the 1,000-foot rule, but once again, not Senate Bill 1, pre-existing, 1,000-foot rule is enjoined. And then finally, I would have preferred to win on everything, but what's going to probably affect the vast majority of you in your daily lives is the private building consent rule. That's the one if you're going to visit your brother, your mother, your father, going to see your neighbor, going to the bank, going to the CVS. they said that you cannot prevent people as a default, the populace, from carrying firearms into those establishments and put the onus on the establishment to permit it. So, if the establishment conversely wants to ban you from carrying firearms in there, I just happened to walk through the main entrance of this wonderful establishment. There's a sign there that says no firearms on the property. That is their right as a private entity to do so. But you cannot, according to the court, presumptively ban the carrying of firearms at everyone's house, business, etc., without their consent and without putting the onus on them to post a sign to allow people to exercise their Second Amendment rights. So there is going to be a great multitude between that of locations where you could, as long as this injunction is in effect. And remember, it is but an injunction. It can go away as quickly as it came. So make sure you are following it. Make sure you are supporting the Second Amendment. But while that is in play, you are free to carry at a wide multitude of private establishments in the state of Maryland without requiring express permission or there to be signage. If that is reversed, that goes back into effect. But until that happens, that is a tremendous victory.
So pay attention to what's going on because things can and do change, both for the good and the other way.
Unfortunately.
Right. So all is not lost. Don't hang your heads in defeat. So what we'd like to do now is we're going to go ahead and open the floor up for questions. I would just say we ask that you come to the microphone. That's so that everyone can hear your question. And speak directly into the microphone, please, and just keep it as succinct as you can. We're going to run the question and answer period till about 8 o'clock. Yes, sir. Please, to the microphone.
First question is, on the USCCA website, it says that in this state that they can't enforce the signage rule. Am I missing something here?
Are you talking about the injunction?
With the signs.
What can you ask that question a different way and more specifically?
Are the signs enforceable? Because you just said there was a sign on the other side of the building, but on the
They can make you leave. They can tell you to leave if you've got a firearm on you in here. I'm sure the legislature is going to potentially impose criminal penalties coming up next January when they meet for 90 days. But this second, that is not a crime in and of itself.
Right.
As of October 1st, with Senate Bill 1 as enacted, absent an injunction, it would be a crime in and of itself being in here without a sign like this or express permission.
But the injunction is in
Yes.
fact in effect. I think
Yes.
the question being is if you go to a mall, for instance, and there's a sign that says no guns, does that sign mean that you can't take guns in there? That's what you're getting at. So they, as Andrew said, they would simply ask you to leave if they found out somehow that you had a gun currently. And if you chose not to leave, then they would tell you you'd be trespassing, you'd be guilty of trespassing.
And
if that answers your question.
Back to the question too, how do they know you have a gun? Once again, if it is visible or if you are printing, that still is a problem you're going to have to deal with.
Right. Because that was not enjoined.
Correct.
Right. So the concealed carry portion of it still remains. Any other questions? Don't all jump up at once.
Mine's more of a concern. I tend to fight things with financially. When I find anything that stands against what I value, I don't financially support them. So that's basically how I fight with. And I think it's successful. I think that's where a lot of us who have values and beliefs need to really step up because they need us. There's a lot of people here. And this ain't all of us, you know what I mean? So, I mean, I really just believe that if we stood up and it might be inconvenience for us because it's inconvenience for me. It's not easy. It's not simple. But you got to take a stand somewhere. You got to stand up for something, you know? And that's where we hit them at their pocketbook, you know? They don't want to support us, our Second Amendment, then we need to stand up and not support them, period.
Vote with your wallet.
Absolutely. Absolutely. Very good point. Very good point. Yes, sir. Come on up.
Two quick questions. Did you say that the state parks, the, what do you call them, the other wildlands, and all those lands that they mentioned, did you say that that was enjoined?
That was not enjoined.
Okay.
You cannot carry a firearm in state parks, Chesapeake Bay lands, things of that nature.
And the other thing is, after you renew the first time, and then you renew the second time, oh, excuse me,
The subsequent renewal,
yes.
okay?
And then is there classes involved in that? And
Yes.
extra fees?
Yes.
So that's eternal.
Yeah,
The way
yes.
things look right
So,
now.
so it's a 16-hour class for the initial qualification for the initial wear and
Right.
carry, and then an 8-hour class following that.
So then,
And they did raise the fees up on those as well.
right, so, but your next, then, after that, you got to go through the classes again?
Every time you renew, you have to go through the 8-hour class and requalify. Yeah.
Okay.
But that was not changed under Senate Bill 1. That was something that was pre-existing from 2013.
Okay, thanks.
Yep.
Appreciate it.
Yes, sir. Come on up. We should add 2 microphones, one in the back, one in the front. Make a
We'll
note
see
of
you
that.
after the Fourth Circuit rules. We'll have
That's-
more microphones
We'll
next
make
time.
sure we bring more.
Gentlemen.
Yes, sir.
Two, if I may.
Yes.
Please.
The first one in general, the statement you made about it being said that they had ample evidence about certain things being legal. I'm assuming they gave citations for that. We weren't just taking their word for it.
No, they gave citations. We'll go to just parks because it was one of the last things
Right.
mentioned. Historically, there has been ample precedent cited in here and agreed to by the court of public parks being opened by municipalities throughout history and banning firearms in the parks. A lot of it was designed at stopping hunting in the public parks. So these are the things that we are going to have, I am not a party to this lawsuit. I am not representing anyone, but these are things that you would bring experts in to testify, cross-examine them, they in here, and I don't want to go too crazy, the court shoots this down. The state cites in support of banning firearms, black codes that would prohibit African Americans from possessing firearms as showing the rich tradition of firearm regulation in the United States of America. The court was not impressed by that.
Well, I'm assuming by precedence that we're just simply talking about court cases that have.
Now, laws that would have been passed by any kind of municipal, state, city government around 1791, passed or in effect around 1791 or around 1868.
And yet Heller, Bruin, and those cases didn't subsequently overpower those. And
Heller, you got to remember too, it's been a slow ride here. Heller and some of these other cases you
I'm
deal
getting old.
with.
I'm getting old. They got to speed it up.
Fair. They deal with Washington, D.C., Chicago, saying you couldn't even have a pistol in your own house, period. Within the confines of the District of Columbia, one could not have a handgun. It clearly was effective at stopping gun violence and homicides, and everyone thought of D.C. in the 80s as a wonderful paradise.
A utopia.
Yeah,
Utopian
yeah.
society.
People were eager to move there,
Yes.
particularly all quadrants.
Right.
So the natural progeny of that is things are moving, and these case Heller and things you cite, once again, they allowed what now seems basic, but that you could have a handgun in your own home, not take it anywhere, but just even have it in your own home was verboten prior to that.
Elk Neck is a state park.
Pardon me?
Elk Neck is a state park. Elk Neck has a shooting range. I'm presuming that according to what you're saying, I can't carry in Elk Neck, I can transport safely.
Well, no, but it would limit your ability. There are exceptions if you're going to the shooting, not specifically, it doesn't say the shooting range in Elk Neck Park, excuse me. If you were going to a shooting range, the rules and regulations of carrying a firearm to a shooting range would apply. Has to be unloaded in a locked enclosed case. You could not, and this law, there are issues, and this is a good point. I would be happy to argue either way, but I would argue you theoretically, if you were going to the shooting range, could possibly carry concealed all the way there. But the state, if they really want to, could say, oh no, you had to be not carrying concealed. It had to be in a locked enclosed case and unloaded from the second you stepped on the edge of the park to where you walked to the shooting range.
Thank you.
You're welcome. Any other questions? Step up, come on up to the mic.
Line up.
Yeah, if you go a lot faster, if you guys want to ask questions, just hop in line.
I guess my question was, you said that they were looking at all of Maryland's kind of laws.
The whole of the United States at the relevant time. So 1791 and then again in 1868.
Okay, well, I guess my question kind of is, will they ever look at the HQL laws then? Because to me, and I've always said this, I think they break our Second Amendment rights from giddy up. They say, get the HQL. Okay, I get the HQL. They look up my tail end with the microscope. They say they do a universal background check, which I still haven't figured out, and neither has my FFL dealer. And then I have to wait again for a background check when I get a handgun. And I'm wondering, does that look odd to other states? Does that look odd to a judge? Does that look odd to anybody else who believes in the Second Amendment? And is Maryland imposing on my Second Amendment rights by doing that? And with this very case, would the judge look at something like that and say, look, what are you guys doing here? You know? I mean, would that be something that would be looked at in this whole realm of crap that is being put forward?
In this case, no one has challenged Maryland's statutory regulations with the HQL. There have been other cases about that. They are continuing to work their way up the appellate court, but so far, any challenge that the HQL itself is infringing upon the Second Amendment or the 14th Amendment has failed. And it is not a part of this specific lawsuit right now.
Well, thank you.
Thank you, sir. Next.
You was talking about the private property, not being able to carry on private property.
Yes.
I'm carrying to work. All right. What am I supposed to do when I get to work?
Does your employer not like the Second Amendment?
Well, that I don't know if the law passes.
Well, okay. The law passed.
Yeah, but I'm
That happened.
with the injunction.
Okay.
Yeah.
So under the injunction now, you're okay.
Right.
As long as it's concealed the whole time.
Yeah.
If the injunction is lifted, you have to have permission, depending, I don't know what you do for work. If you work at a hospital, for example,
Right.
doesn't matter. But if it is a entity that is not a banned location, you could carry. If the injunction is lifted, you would have to have express permission from your employer to be carrying on the property.
If I put it in a lockbox in my vehicle, would that cover me when I went onto the property?
So you're leaving it outside, locked in a lockbox in your car?
Yes.
And is this, are you parking in a parking garage? There's a lot of variables
In
there.
a parking lot.
And
you know,
a parking lot or a parking garage?
Parking lot.
Okay, a parking lot. Is it open to everyone or
Yes.
is it,
Yes.
I don't work there. Can I just go park my car there?
No.
Okay.
Somebody's going to question why you're there. You know.
You're at a sticky situation there. You probably are okay, but once again, this law was not thought out to help you.
Right.
Clearly.
Yeah. That's what I was wondering.
Yeah.
Now, another question. Can they ask you if you're carrying?
Anyone can ask anyone if they're carrying.
But you don't
Do
have-
you have to answer? No. Can they then say you're fired? Yes.
Right. Okay. Yeah. But I don't have to show it.
No.
Yeah. Okay.
Once again, no. But once again, you're fired if you don't.
Do me a favor. Thank you.
from the back can't hear you. If you guys talk directly into it, that'd be great.
Great. So speak into the microphone. Thank you.
Earlier you were saying about with the lock boxes for the vehicles, that the gun would have to be locked in a lock box. Now, certain vehicles like mine, I have a Silverado, in the center seat, underneath the seat, there is a key lock box. Is that considered, would that be falling in that junction, or do they want me to buy in a separate system?
I think it said not the glove box or not the console.
Well,
I don't
it's
think
not
that
the console,
qualifies.
it's underneath the seat.
Right.
So I have the center console, which you can just flip open and throw
Right.
it in. But if you flip up the whole thing, there's another box that has a key lock.
You asked a
do you-
rhetorical question. What do they want? They want you never to carry your firearm ever. That's what
Yeah.
they want.
But they were saying, you were saying earlier about
Yeah.
they want it in a lock box. Is that considered a lock box?
No, it is not defined what it is. If you get in trouble for you've got it, and this is I don't know, I've never seen your Silverado, but this is like a truck vault is what you're describing.
Right.
I think any 12 people with any degree of common sense would find you not guilty.
I would say as long as they could determine that it wasn't a console or a
Right.
glove box or
Right.
something like
Yeah,
that.
because
So,
you don't even know it's there unless you have that type of truck.
Right.
yeah, you're probably okay.
This law is new, went into
Yeah.
effect October 1st, has generally been untested. I hate to say that, but I
Right.
can't give you a concrete answer.
And not seeing your truck is why I said probably.
Yeah.
Okay. Thank you.
You're welcome. We good on the sound in the back? Good, okay.
Hi,
Hello?
Hi,
I need clarity.
please.
Daycare home facility.
Mm-hmm.
Could you please explain where we are today with regards to the law, with regards to, like, can I carry it? Can I
Forbidden.
put-
In a daycare facility, you cannot carry, period.
Are you the owner of that facility?
Yes.
You are.
Okay.
Okay, so the owner or the leasee of the
Yes,
property, that's where it
yes.
falls, okay.
Okay. There can be exceptions for you as the owner of the facility that need to be very careful with that, but there could be exceptions for you, yes.
So I had a similar question. I reached out to Maryland State Police Licensing in regards to that. It was the owner of a large daycare facility. So this wasn't one inside of like a home, it was a larger one. And they did advise that as long as it is the owner or the leasee of the property, that it falls under that. So you would be covered there. But I think, are we talking about a large one or inside of somebody's home?
Home.
Home. So I think also there's a provision that talks about that firearms cannot be stored on premises. So, yeah. That
Thank
was
you.
the answer that they gave us. Or that was the answer that they gave me.
Okay, thank you.
So you're welcome.
Hi, I need clarity too. I have a question as far as in your home, you're allowed to have the gun.
Speak a little
right?
bit into the mic, a little bit more.
In your home, you're allowed to have a gun, correct?
You're not a convicted felon, correct?
Yeah, are you a prohibited person?
There's a lot of intricacies there.
Yeah.
Okay, we're going to assume that you're not a prohibited person, so yes.
Correct. So let's say you're talking about signs in the window if someone gives you permission to have the gun in their house, right? If you have a neighbor that you talk to and you want to give them permission, or they'll give you permission to have a gun in their house in case anything happened and you want to help them, does there have to be a sign in the window, or can you give each other permission?
Express permission. Well, once
Meaning
again, this is
written down.
enjoined. So right now I can carry a gun into my neighbor's house all I want. But if this law as enacted, you would have to have express permission from your neighbor, or they would have to have a sign up.
Okay, the reason why I question that sign is if you put a sign in the window, you're asking a burglar or a rapist to come in your house and have a gun. So I want to make sure that you can have express permission, which means even something in writing. Is that
Orally, oral express permission obviously is worth the paper it's written on if the person says I gave no such thing. But
But
it
written
could be
permission-
email, it could be written, it could be
Written,
telegram. Yeah,
Yeah, written, they can't dispute they gave it to you. Orally, they can.
correct.
Okay.
Yep.
Thank you.
You're
Thank
welcome.
you.
Next question.
Hello.
Hello.
I read a,
Speak, I know it's low, I apologize, we didn't, there you go, Ed. So the people in the back can hear. There you go.
Thank you. I've read several different opinions and
Maybe just hold it when you.
and several different articles in reference to SB1.
Uh-huh.
And in one of them, there was reference to when you're carrying concealed, that the gun that you are carrying has to be in your name. Whereas a lot of people inherit guns. I've had them for,
Nowhere in SB1 does it say that.
okay,
Everything you read is always true, I agree, but
until it's not. Is that anywhere in Maryland law?
in Maryland, well, this is a complicated. yeah.
Well, so I would say that is, I have not seen that, where it says that it has to be registered specifically to you.
I had never seen
I
it
would
either.
say that it should be lawfully owned, but that's a good question. I can't answer that right now, but I don't believe I've ever seen that in writing anywhere in any of the teachings or curriculum that I've reviewed from the Maryland State Police or any of the stuff that we teach.
Okay, thank you.
You're welcome. Okay, this will be the last question. Come on up, sir.
Thanks to the tall people.
Yeah, we should have had him be last, right?
Yeah.
You were turning the wrong one, Ed. There you go. Okay.
My question is, as it relates to a child care facility within a house of worship. So in our county, we have several churches that have either tenants or as a subsidiary of their house of worship, daycares and subsequent surrounding property. So my question is, as long as it's not occupied by children, are we okay to carry in the church or on the grounds?
The people who drafted this law did not sit down with the common sense contained in this room alone when they thought about this and passed this. The law doesn't say a licensed daycare facility while the children are there. Is this a licensed daycare facility in the church?
Yes, it is.
And does it take up the entire church or only a portion of the church?
A portion of the church.
I would say, as written, that you probably could never carry a fire with the exceptions of, without an exception, if I'm just a regular member of that church or I just happen to be visiting that day, I probably could not carry a concealed firearm at any point into the daycare facility that is a part of it.
Thank you.
You're welcome. Okay, so as we bring the speaking portion of tonight's event to a close, I'd like to remind everyone that our guests will be sticking around for a little bit and be available for discussion at the conclusion of the event. Also, check out our vendors, see what they have to offer, and purchase something from the VFW. Check them out. Don't forget about their shrimp beer. Oh, I'm sorry, shrimp beef and beer. I thought it was two beers. Shrimp, beef, and beer. Check that out. So for Maryland gun owners, Tactical Shepherd, Urban Defense, the USCCA, the VFW, Post 6027, our guest sponsors, vendors, staff, and everybody else, thank you for attending. Use good judgment. Stay safe out there. God bless and good night.